are you?
Hi, Brooke. We're back.
I know, we haven't seen each other all day. This is the first time. So we are going to do some celebrity stories today. I know you have kind of a bigger story, and then we have a couple little tidbits we want to touch on. I think it's the right way to put it.
Yeah, I think so. I think you've already kind of given the viewers background on the Jeannie, Mai, and Jeezy divorce.
Yeah, and let me just say, yes, Jeannie.
How were you saying it?
I was saying it Jenny May, and it is Jeannie Mai. I'm sorry.
She's learned.
I've learned.
Give us grace. As you know, or you've already covered, she was married to Jeezy. They got a divorce. My understanding,
they've filed for
they
divorce.
filed for divorce. Yes, and my understanding is that she wasn't aware the divorce was coming, and we've been kind of following the story of their divorce proceedings. And at one point in time, he made a motion to have sole custody of the children, their one child that they share together, legal and physical custody. She since has responded or made claims of domestic violence as well as irresponsible gun ownership. And we wanted to kind of talk to the viewers today as to how that's going to impact custody as a whole, because you obviously have two parties who are on very opposite sides of the spectrum right now in terms of their requests with respect to the minor child too. They have a little girl. I don't know how old she is, but I know she's young, very young. Yeah.
I think before we get into the latest, we should touch on his request for sole physical and sole legal custody. So I know you have dealt with this. We have clients come in very often asking for that sole legal and sole physical custody of the child. What do you do when your clients come to you and say they want to ask for sole legal and physical custody?
So what I usually say is, absent a domestic violence restraining order, it's not very likely this request is going to be granted, or extreme circumstances. The courts typically have been more inclined to grant not even necessarily equal timeshare, but sole is a pretty extreme request. I view it as an extreme request. Now, taking into consideration that this is a very young child, that would be a major factor in how I advise the clients, because certainly whoever their primary caretaker is, whether it be mother or father, is who this child's going to spend the majority of their time with as they kind of work towards more custodial time. When a child is so little like that, it makes sense to have some sort of step-up custody plan.
But even that, I think, so this is a common misconception that sole physical custody means only one parent is seeing that child, period. Where I think people then think joint custody means it's an equal 50-50 timeshare split. And we know that not to be true. So a parent can have sole physical custody, and the other parent is still getting visitation, still seeing the child. It's going to be much more limited, though. In joint physical custody, you can have a parent who has the children, only every other weekend. And that's obviously the children are with one parent a lot more than the other, but it's still going to be joint physical custody. So which is why I think it's very rare to see sole physical custody. I think it's probably, absent
domestic
violence or geographical issues, I think it's more likely to see
joint orders.
I was going to say sole. I was thinking of sole legal versus sole physical.
What I think I'm getting at too is, like, clients, despite the misconception that sole physical custody can still grant visitation to the other parent, clients are often asking to have 100% of that custodial time with the child when they're saying sole physical. And then to speak to your point about sole legal custody, same thing, right? Courts are more inclined to give joint legal custody to the parties, again, absent certain facts or circumstances warranting otherwise. And we've maybe talked about this a little bit, but legal custody pertains to decision-making related to the child. And again, sometimes there's certain orders that are appropriate when the parties can't co-parent together, making it too difficult for them to make those decisions.
To exercise that joint legal custody.
But to your original question, I'm typically advising clients that, the court's not going to be probably as inclined to grant you, using the terms that clients are speaking of, 100% of the custody time.
Correct. I think it's also interesting with sole legal custody. I really only see that getting ordered outside of domestic violence, which we'll get into, after a really drawn out battle, where kind of what you were talking about, where the court is like, these parents can't exercise sole or joint legal custody. They just can't co-parent, and you need to be able to co-parent. And so some of those other options the court has is granting either sole legal to one party. They can also kind of divvy up what the legal custody is going to entail. So maybe mom gets decision-making for medical decisions and dad gets school choices. They don't even trade off like that. It could just be joint legal custody with mom having
tie-breaking authority,
sole legal decision-making when it comes to medical decisions, things like that. So they can get a little crafty, but I don't, you're never supposed to say never or always, but just about in every case, it would be very rare to see that order be made the first time you go to court.
Yes. And just to speak to the facts of this particular case, Jeannie, Maya, and Jeezy, I haven't read his moving papers, of course, and I don't know the details, but from what I've read in the media, one of the underlying reasons he's asking for that is because she works and she travels for her job, and he's alleging that the minor child is in the care of the grandparents the majority of the time, and therefore it makes sense for him to have 100% of the custodial time with her, or at least the majority. And I've had clients who are working parents ask me this, and the advice, and maybe your advice is different, but my advice is typically, the courts understand parents need to work, so they're not going to punish you for being a working parent, but they may, if it is possible, given your work schedule and it makes sense for the child to be in the care of the other parent rather than the third-party caretaker, they may make orders to accommodate that. But again, that's fact-specific, and it just depends. But, being a working parent is not something the court's going to punish you for. And I think that making a claim that the child should not see mom is not in the best interest of the minor child. Not see mom because she's working is what I should say, is not in the best interest of the minor child.
I agree with you. And also I would point out that, let's say what he's asking for is right. You can do that custodial visitation under a joint physical custody order. I guess actually I probably should have started with this, but we are talking about this case as if it were in California. We know it's not. So
I actually don't know where it's filed.
I thought it was Florida.
Okay, that checks out.
So Florida may be different, but we are just speaking as if this were happening in LA Superior Court. Right. So I completely agree with you, and that would be my advice to my client. It's going to look pretty bad that you basically want the court to punish your spouse for working. It's not a great look. That's exactly what I was going to say. And so, you are always trying to look so reasonable to the court, because, all of our clients are, of course, so reasonable, but we just want to make sure that they come off very reasonable in court. And so if you do have a legitimate concern about the other party's ability to parent, you can say, I want joint physical custody with a custodial schedule that takes into account,
their work
respondents' work schedule. You can be creative in your requests.
Right.
I think it's a bad move to go in your first filing saying she works, so I get sole physical custody and sole legal custody. I don't think that looks great.
What I always, one of the first things I say to clients when we're talking about custody is we're the standards best interest of the minor child. So when we are kind of keeping that as our starting point, then we can make the orders accordingly. And I think all of our clients, when it comes to custody, are doing their best to think of the best interest of the minor child, but we can kind of give them the lens of how the judge may perceive a request and maybe work on the language or wording. And I think in this case, again, I haven't read his moving papers, but the media is reporting that that's his claim essentially is, she's working. And again, it's just not a great look if that's how it was presented to the court.
I like that idea of how you're presenting it to the court. Something that I learned when I was, I think, first clerking, and this is just, kind of a practice tip. I think it was Don. He doesn't like to go to court and say, we want 70-30 timeshare or 50-50 even. He likes to say that we want this visitation schedule, not even get into the numbers, because it's showing the court that you are thinking about what actually works for the children and not what is like some number that you're going to plug into the disto master and it's going to affect child support. If you come in and say, well, I work on Mondays and Tuesdays, but I'm not on Wednesdays and Thursdays, so I should have these days and mom gets these days, it just looks better because it looks, it looks better.
But it is better, right?
It is better. You are actually taking the time to think about how this custodial schedule is going to impact your children. And obviously that's what the court wants to see you're doing. So when they see you're doing it, it puts you in a better light. Yeah,
I think, when I was a brand new baby attorney, I was so naive, and I I remember, more senior attorneys saying, well, did you calculate the percentage of custodial time? And I was like, what? I'm just looking at like the overall schedule itself, not so much the percentage. And as we know in the state of California, that percentage of time does influence child support, which is what you're implying is essentially if you're going into court, it can look like you're maybe trying to aim for a certain percentage for the wrong reasons to influence your support. But again, luckily, more often than not, we work with wonderful clients who, and again, I think most parents who are in court disputing custody really do have the best interest of the minor children at heart. It's just the different perspectives that exist.
I agree. So we've done a lot of talking about custody.
Yes.
And let's now discuss how a domestic violence restraining order or finding of domestic violence impacts custody, because that is now what is happening.
Yeah. So essentially, what has happened is, again, I don't know if it's a response or a separate filing, and it doesn't really matter. But Jeannie Mai is saying essentially that there's been domestic violence, and she's presenting quite a bit of evidence to support this claim. Again, I'm not suggesting that there is a finding, but she has presented evidence. I believe there's third parties have witnessed this. There's some surveillance video footage that's been released of him. I think they're in a stairwell and he hits her. I'm not sure of the details, and I don't want to misstate them. And then also photos that have been submitted of guns, left out in the open. And so she's claiming domestic violence has occurred, as we've kind of already alluded to. And to answer your question, a finding of domestic violence is hugely impactful to custody. In fact, when clients come in and there's a pending domestic violence restraining order on calendar, and there's children, the first thing I'm going to advise them of is the 3044 presumption. And essentially the 3044 presumption states that if there is a finding of domestic violence, then the abuser cannot be awarded sole legal or sole physical custody, nor can they be awarded joint legal or joint physical custody until they overcome that presumption. And there's certain factors that are set out, which we can touch on. But to your point about custodial time and percentage, the courts haven't been totally clear on what joint percentage is, but you're not looking at 50%, right?
You're fighting an uphill battle to get to 50%, I think.
Yes. And some of the factors, I don't know if they're not so much relevant to this discussion of this particular case, but just to touch on them, you can go to anger management classes or parenting classes, therapy.
Drug and alcohol classes.
Yes.
Relevant.
Yes. So there's certain steps that you're going to have to take to show the court, hey, I've done the work and now I'm ready to assume more custodial time, and that you have to file and obviously go into court and make that request. So that's a huge finding, right? If you have committed domestic violence and the court finds as such, you're going to have very limited custodial time with your child.
And I think it's also important to note that there is not, you alluded to this, but there is not case law which really states what joint custody is and what that looks like. So when you're going into court, if you're defending yourself from these allegations, you really don't know what the worst outcome is for you. Because we've been there where, the custodial schedule ended up being, alternate weekends, which I would find kind of, pretty significant amount of custodial time. And does that go against the 3044 presumption? I don't know. It's hard to say.
Yeah, we actually did. I don't remember the case off the top of my head, but we did a podcast on this, Dawn and I, and that case was specifically that, right? The judge had actually ordered quite a bit of custodial time, and so it's not clear right now, and sorry, just to be clear, they ordered that without finding that I think it was the husband in this case had overcome the presumptions. Yes.
So we're not saying that you get a DV finding against you and you'll never have your kids ever. But the presumption is it's not in the children's best interest. And to overcome that presumption, you look at these factors we've kind of touched on. And after finding that you've overcome the presumption, then the court
can order additional custodial time that reflects something of joint or otherwise. But
then just what we're finding and what we've seen in other cases is that judges are ordering what looks like joint physical custody without after a finding of domestic violence, without finding that they've overcome the presumption. So,
and not always, right? That's what we're kind of getting at, is the pendulum can swing, right? It can be a judge who says you're only going to get
an hour on Sunday.
Or it's monitored visitation, or there's a lot of discretion to the judge, at least in as the code's written right now, and we see that in case law. Yeah. But so these are claims that, and just to be clear, I don't know if he's alleging that the child has witnessed this abuse or has been a party to the abuse. I don't think she is saying that he's abused the child, but nonetheless, the child's probably been present to some extent. So as we're seeing, if there is a finding of domestic violence, Jeezy's request to have sole legal and sole physical custody not only is unlikely to be granted, but he may not even be awarded joint, right? And again, this is speaking to California. We don't know the specifics of Florida law, but if it was California, then certainly his motion for custody is probably going to be greatly impacted by this claim.
I would find it hard to believe that a DV finding in Florida wouldn't impact custody.
Yeah, I'm sure there's something akin to the 34 presumption.
I would assume. I would think so, but if not, Florida, let us know.
Someone from Florida comment, let us know.
Okay, so another couple or former couple I wanted to talk about was Isla Fisher and Sacha Baron Cohen.
Yes.
They have separated after I think 13 years of marriage, but they've been together a really long time. So it's a little sad. We haven't really seen anything. They've been pretty private. They just posted a story on Instagram, and we haven't seen filings, or I haven't at least. So this is all speculation, but it's a good jumping off point. So I read that part of the issue was that he is an English person and she is Australian, and there were differing opinions on where they should be. Her father recently died, and that, brings up a lot of feelings. She wants to be close to home. So we've talked about this a little bit in the Sophie Turner and Joe Jonas case, but when you have two parents who are living or who want to live in two different countries, two different continents, what do you do? And so obviously they're not, in the U.S., but assuming this was in California, they would have to show where the home of the child is, and that court would have jurisdiction. Yes,
and then they're going to have to get creative as to their custody orders going forward, because it's challenging when you have that much distance, and unlike, parents who live up the street or 45 minutes, right, where you can exchange custody, make a custody exchange fairly easily, you're not going to have that if people are living in different continents. And
I think what we see the most often is one parent during the school year,
one parent during the summer,
and then one parent during the summer and major holidays.
Yes,
I mean, I don't know, is Australia...
Even holidays is challenging if you're that far apart. So you do find probably that one parent is at some degree going to have to make a sacrifice to be close to the minor children. They have minor children, right?
Yes.
Okay.
Yeah, because David can tell us. Australia, can you go there for 1 week? I mean, obviously you can. That's a lot of travel for just a few days.
It needs to be at least 2 weeks to make the flight.
Yeah, I think that makes a lot of sense.
Yeah.
So that's not spring break.
Yeah. Another consideration, again, when we're talking best interest of the minor child, is that good for the children to be making that travel? There's no way around it. They have to be the parties making the travel. I mean, sometimes the parents can come to the children as well, but more often than not, you see that the children are traveling to the parent.
And even when they're not in school, so it's not disruptive that way. Summer was the best time for me when I was growing up. You didn't have to go to school. You got to be with all of your friends. But now, in these situations, the children have to leave that kind of free zone with their friends. And and that's hard. It's not in their best interest.
Yeah, and sometimes it's inevitable, right, for work, or otherwise parents have to make it work, or whatever it may be. Obviously, there are circumstances that make it necessary to have that type of custodial schedule. But certainly a major consideration when you have parties who are living so far apart.
Yeah.
I'm really sad that when I saw that announcement, I was really surprised by that, because they're very private anyways. Very private. In fact, when I found out they were even together, but I adore her. I don't know a lot of her work. His work, I should say, but I just think they're such a comedic couple, and then the separation was kind of a surprise.
Yeah.
But yeah.
So we had one more couple to talk about, Natalie Portman and her husband. And I might pronounce this wrong.
Now you're so paranoid. You're like, I'm so sorry in advance.
I know. If I pronounce it wrong, just no comments are needed. I'll feel the shame more than you know. Benjamin Millepied. He's French, so I should be able to pronounce his last name better. Millepied.
We need Antoine here.
I know.
Can you please clarify?
Please tell me how. But they have, I think, 2 children. They got together during Black Swan. He was the choreographer.
Oh, that checks out. Okay.
Yeah, so that's how they got together. And it's come out, it seems pretty clear that he cheated on her, potentially more than once, and she is moving forward with a divorce. very private couple, and so unsurprisingly, they are private in this divorce as well. But I thought this would be, actually, you thought this would be a good idea, just to remind viewers that in California, it is a no-fault state. Cheating does not need to be proved in order to get divorced. You can get divorced for really whatever reason you want. You have irreconcilable differences, and you just don't want to be married, and that is enough for California. So cheating would not play a role in their dissolution here.
Yeah. And just to take it one step further, I think it's kind of implied by what you just said, but obviously it's not going to impact property division. It's not going to impact custody of the children. And we see this, I've had clients where there has been infidelity, and I find it hard sometimes when they are, the client who has been cheated on to deliver that news that there's really no remedy as it relates to their family law case. At the same time, obviously, the courts can't be getting involved in. Although when we had a podcast about this, you've informed me since that like Georgia and a lot of other states actually do get involved in infidelity, which to me is so mind-boggling coming from someone who practices in the state of California.
So in a couple states, so every state in the U.S. you can file a no-fault divorce. There are just some states that also give you the option of, when you're filing for divorce, filing for a fault divorce.
Interesting.
And that, if you can prove the allegations, and it's more than just cheating, and it will impact the property, it can impact the property division, the alimony, support,
really
which I thought was very interesting. I don't know. I think I land that no fault is the way to go just for everyone, but it's pretty interesting.
From a litigation perspective, absolutely. From a client's perspective who, either has cheated or has been cheated on, it might be a little bit more nuanced or complicated. But from a litigation perspective, I think it's very messy to have to prove these allegations and these claims. And
I think it's also bad for the family if you have children at home and you need to kind of live in this bad behavior, as part of the litigation. I think that could be painful. And
well, also keeping in mind that these are public proceedings, and so they are, these filings are accessible and they live in time forever. And so even separate and aside than cheating allegations, any allegation you're making against another parent, sometimes I've had to advise clients of that, right? That we can put this in the moving papers. Are you sure?
Once you
once it's out there, it does live in the public record, and it will be there. And if their children do grow up and they, I hope, are not accessing, obviously clients need to plead their case. I'm not suggesting they shouldn't, but it is complicated, this balance of the children being involved in family law cases and the parties themselves. And another layer of complication is just, these are marriages, these are people. It's not black and white. It's not. So when you do have claims of cheating and whatnot, I mean, the law has simplified itself in California to say, we're not getting involved.
Okay,
no fault.
With that said, I think in any case I've had where cheating was a part of it, whether it was my client being cheated on or being the cheater, the cheating allegation makes it into the filing.
Some way,
every time.
Yes, this is true.
It has no bearing on anything. Yes. This is such a lawyer thing. The smallest caveat is if community funds were being used on the affair partner, that can be an issue.
We didn't touch on this. Yeah, that is a breach of fiduciary duty.
That is the one time it's going to come into play. Yes. But regardless, it's in every pleading.
Yes.
And it's in every pleading of that case, pretty much.
Yeah. Yes. Yeah. I haven't luckily had it with minor children involved, but I've had it in cases with property. Mm-hmm. And I've had it in cases with reimbursement claims with respect to breach of fiduciary duty. And hard to prove. Again, like it gets messy, right? How do you prove
Where are you gonna go get
that community funds were spent on this other partner or on an affair? But
it's messy. And we just deal with it the tiniest bit.
Right. Imagine if you open up the big box of, Yeah.
You know how I know no fault is better? Is because I'm thinking of if I had been cheated on and I was getting divorced, I would spend all my time on that cheating and nothing would get done. And so by California not giving me that option, they're really saving me some time and frustration and money.
It would just make the cases, like you said, to your point about attorney's fees, right? Mm-hmm. If you're having to prove these claims, it becomes an evidentiary issue. And anytime where we're dealing with evidentiary issues, it's costly. And it's not really something you can, I guess you could in theory stipulate it to it and say, yes, I cheated. But
I don't know why they would.
Yeah, we're getting in the weeds now about legality. And again, to bring up Natalie Portman and her husband, but again, like another shocking. They're private, but
They're private.
Who would cheat on Natalie Portman? Did you know she went to Harvard?
I did know that. She's great. She is my boyfriend's.
No, she's Matt's celebrity crush too.
Oh my god, they have so much in common.
Yeah, when Matt told me that, I was like, oh, okay.
At least you're small like her.
I didn't go to Harvard, and
You went to this right after Harvard.
But yeah, Matt's like, not anymore. I'm like, okay, so you say.
So sure.
It's fine. I mean,
at least he lies to you. Anton is like,
no, still.
That's number one.
You kind of look like Natalie Portman, right? Like you have petite features too. That's so funny.
I don't feel like I've ever described myself with like
me
petite.
No, me either.
Like
yeah, no, me either. And when Matt told me that, it was honestly shocking because I was like, well, we look nothing alike. But thank you. Okay.